Hi everybody, Jake Fouts here.
And Brian Fouts.
And we have our good friend and one of our most popular advisors, Kevin Day, back. And he's going to be building on today, talking about different types of trust. I think you're going to be talking about offshore trusts, a little bit more about irrevocable trust, and kind of how those work for us and our members.
Yes, so this is the, fourth segment of the asset protection, lawsuit protection. The last two were covering strategies for either just W-2 households that were growing that wanted to lawsuit protect their affairs, and then one strategy of many that can be used for business owners, equity stripping that's scalable. We just drew this triangle of the trust, but really didn't explain how many different trusts there are. So we're going to make this a short kind of segment, maybe 20, 25 minutes max. But I want to give you a history of trusts because they are unique to common law. So we grew out of the English law, and so trusts run back to the 10th century. And it was really dealing with the separation of church and state, and all the land belonged to the king or the queen. But I would give you rights to use my land because you helped me win that battle. And as long as it stayed in your family and you used it the way the rules were, called the law of uses, you and your family could keep the property. Otherwise, it would revert back to me, the king. And they'd say, hey, we want to carve off in our property a place for a church or something like that that were prohibited. And so they made these trusts, and then they became popular during the Crusades as well. They were always irrevocable, non-changeable trusts, these trusts. And it wasn't until, I think in the 30s or so, where trusts became, they invented a version called a revocable trust. So that's why a lot of people say, oh, I have a living trust, therefore I have lawsuit protection. Somehow it comes through the vapors that just a trust by itself must mean irrevocable and therefore lawsuit proof. Because I have a lot of people say, oh, I already have a trust. Well, let me look at it. Yeah, you have great estate planning, you want to do it, you want to avoid the cost and time of probate, but that's not lawsuit protected at all. So these trusts, until fairly recently, were always irrevocable. And the only way to really get it, again, I'm going to use a nuclear family, mom and dad, set up a trust, and they will ask uncle, in my example, to be a trustee, and the beneficiaries were going to be their 3 children. So the only way you got a lawsuit-proof trust was the original owner to give away all ownership and control. And that is a lawsuit-proof trust that runs back way into history and is still our law today.
So, question for you, Kevin. We've talked a lot about trust, and we have, I think you called the trustee over here. In your example, that's the uncle.
Right.
So does all of this hinge on the relationship that you have with that person there?
No. Usually we're trying to save money. You're not going to have, Citibank's trust department is going to charge $10,000 a year.
My point more, what if the relationship's soured between you and the uncle? Is there a risk there?
Good question. So a good drafter will draft into here that the settlors, the original owners, can hire and fire the trustee without cause under some restrictions that the IRS puts in it. So we can give them the power to fire the trustee. You know, you named your brother-in-law, but your sister got divorced and you just don't know what's going to happen, whatever. We can you want to make sure that that's in there. And especially if this estate gets large or we want the transfer now, but these people are alive, they can still, the trustee can still come to them about advice on wishes if there's some leeway in here and discretion. But once they're dead, if the estate is large, we'll often have at that moment, will already pre-name, not a big bank trustee because they're too expensive, but a commercial trustee. We'll say this estate is too large and we're going to give some to the kids, but it's so large that we want to hold stuff back for grandchildren and even great-grandchildren. We're going to move it over to a commercial trustee, and there's a lot of very good ones that are reasonable. So this was the only trust that we had until we had the revocable living trust. So this is irrevocable. And then we have what's called a revocable living trust, which, if you recall, is set up, but the people that set it up name themselves as the first trustees, and they're also the first beneficiaries. So one of the reasons why it's not lawsuit proof, it's revocable. You can change it. So even if you did name the uncle and the children as trustees, if it's revocable, you can bring it back to us. The court says you bring it back to yourself so you can give it to the creditor. But even if it was irrevocable, if they name themselves either as a trustee or the beneficiary, doesn't have to be both, either one, they're retaining too much of that ownership or control, technical ownership or control, which we covered in our very, very, very first introduction. What happened in 1988, the US signed the Hague Convention on Trust. Not only did we sign it, we are the main proponent of it. And so at a very high level of law, the US said US persons can set up trusts in other countries, and that law prevails. That's the US law. It was kind of a giveaway. How many people are even going to hear about offshore trusts? They're going to be expensive. They are expensive. But it changed the paradigm. And so for the first time ever in the United States, we could have a trust where they set it up, and as long as they had whatever that country defined irrevocable and lawsuit proof, we have a commercial trustee, but they can name themselves as a beneficiary. That was in 1988. That wasn't that long ago. US law changes really slowly. Entrepreneurs love this. They remember that quote from Rockefeller. The last official interview that he had, he was on his deathbed, and the reporter asked, looking back on this long, great, powerful, fortunate life, what do you think the formula of your success was? And they said, control everything and own nothing. So when you say to an owner, give up ownership, they're actually pretty okay with that. If you say give up control, they're usually not very happy with that. So you want a mechanism where they give up ownership, and it's usually a trust by itself is a little bit entrepreneur unfriendly, because this owner does not want to have to be like a Kennedy grandchild or a Carnation grandchild and go to the trustee and say, please give me a check, or please buy me some tickets to Europe, or please sell this house and buy that house. But if you remember from another segment, being a manager down here at an underlying company does not frustrate or harm the trust. It is being a manager here, having the checkbook, having used to be the owner, being a beneficiary does not amount to being a trustee. So the entrepreneur can give up legal ownership and still have the checkbook and manage all the affairs and decide who gets paid what and how much and when to buy and sell, and nobody's really getting in their way. And so this is the perfect answer. So, business owners love this and jumped on this. It's appropriate. You asked me earlier about thresholds. If somebody's estate is under $2 million, the offshore trust is too big of a hammer for them. If they're over $4 million, even without any liability, they just have a lot of liquid cash. They've sold their business. They have no employees, tenants, whatever. They have enough that their estate's going to grow by itself. All their creature comforts are already taken care of. They should seriously consider the offshore trust. So the question is, between $2 million and $4 million, you need to examine it. You need to try it on and look at your risks, and that's part of what we would do with the client, is go through their risks and compare with our knowledge of other clients. Some people say, oh, I've got this and it's really horrible and I need this. And I said, I mean, it is risky, but it's not that risky. Or some people say, I've got this, and I've got this really high risk over there. And you say, you don't think this is risky? Well, I've been doing that business since I was 20. And I said, so you become immune to it. That's really risky. So we try to help our clients just put everything on the table and see what they need. We have people that might stretch for offshore because they were renting 2 years ago and now they bought a house last year and they just hired 5 more people, and they say, I don't want to buy a domestic trust and then in a year buy an offshore trust. So there's different strategies that might be considered. I have a few people under 2 million that have super high risk that decided they wanted to go that route, even though I thought that the domestic was sufficient. So back to our overall picture. We've got these offshore trusts. We do them in the Cook Islands, Gibraltar, Isle of Man, Cayman, Bahamas, Seychelles. There's a bunch of different jurisdictions. Some of the differences are very subtle. Some of them are pretty significant based on the client's circumstances and what laws we're trying to implement. But what's powerful is that they're recognized in all 50 states. You're not in a gray area with regard to the IRS. They actually have a form for having these trusts. And so the IRS becomes your best ally, biggest part of your defense file, when somebody sues you and says, hey, Your Honor, all the goodies are in this trust and we can't get it. And Your Honor, wink, wink, it's an offshore trust. They must be doing something bad. And we can come up and say, no, Your Honor, the IRS knows about this. Here's our filings for the last 3 years. And the IRS says that this is an irrevocable trust. That's why I have to file this form. So it's a really powerful way to go. And you can maintain control. So in 1997, enterprising attorney up in Alaska said, people love these things, but they're afraid of offshore. You know, even if somebody's well-traveled, they're not usually doing business internationally, and they go, yeah, it's the old boy network. You know, I'm not going to be treated fairly. I want to stay here at home, which is pretty funny because if you think about even our legal system, if a Japanese national or a French national or a Canadian national came in and hired a law firm to sue an American, the law firm isn't going to say, oh, well, we're not going to treat them as well because they're not a U.S. citizen. No, they're going to get the same treatment. The lawyers still want to be victorious. So you're not being mistreated. But some people are fearful of offshore, and that's fine. And we're using deep pocket trustees in most jurisdictions. They have hundreds of millions of dollars under direct management, the trustees we're using. And we're not even giving them the checkbook. The checkbook is here in the United States in a Nevada company. And so we've got belt and suspenders, but if somebody's interested, my job as an EVG educator is to let you examine it and learn, and it might be for you, it might not be. 97, we have domestic trusts that do the same thing at a fraction of the cost. And so I got interviewed by the National Law Journal about 6 months before the law was going to pass. And they said, what do you think about this? And I said, well, it's going to be great if you're an Alaskan being sued by an Alaskan, but if you're from Washington and you're being sued by somebody in Arizona, they're not going to give a rip. And I haven't quite changed my plea, but we do maybe 5, 6 of these a month. And it's the same format, but you're not using a commercial trustee usually, but we do have lawyers and CPAs. They have to be, all the laws are written that you have to have a trustee in that jurisdiction. So if we're doing Isle of Man, it has to have an Isle of Man trustee. If we're doing Cook Islands, Cook Islands. Likewise, if we're doing Alaska, Nevada, Delaware, it has to have an in-jurisdiction trustee. So they are a commercial trustee, but commercial trustees, we can get a CPA or a lawyer to do it cheaper. And so you're still the beneficiary. Now issue here now, and we do the same thing, we give you control as being the manager of this underlying company, which in the equity stripping strategy is the lending company that does the equity stripping and has the piggy bank, has a long-term savings account. It's not recognized in all 50 states. So we do them a lot because there are a lot of people that have less than $1 million estate, but they still have high liability business. Or they say, I don't want, because of our lotto system, to lose my home, so even though I'm not a large estate, I like this set fee, equity strip my home, and know it can't be taken no matter what, or whatever the asset is. And so this is a good formula. Ultimately, there hasn't been a challenge to this trust, and that's the rub. That somebody gets a judgment in a state that doesn't recognize these types of trusts, and they say, hey, fair faith and credit between the states, the US Constitution, you have to recognize our judgment. And then Delaware, South Dakota, or Nevada is saying, no, you have to recognize our trust law because of the fair faith and credit between the states. That's a US Supreme Court constitutional issue, and that hasn't happened yet. So until it does happen, it's the law. We can use it, anybody in every state can use it. You'd rather be in a state that already has this kind of law. And of the 13 or so states that we have now that have passed the law, only 8 of them, I think, are reasonable and have teeth behind them. So even those that say that they have the law, they have too many exceptions or they didn't write it quite properly. But that's powerful, and it's true insurance. We're changing ownership, and it's a good strategy. No matter what the strategy is over here, if it's a W-2 person that we're putting underneath or not. Now, you notice we went from the original trust where the original owner couldn't be the beneficiary of either. Mm-hmm. We invented a revocable living trust just so we could pre-name who our successor trustee would be to keep our estate alive so we didn't have to go to the probate. We now have offshore trusts, and then later in 97, domestic trusts where you can name yourself as a beneficiary under US law. You're still not the legal owner. We still have these trusts, and they're very powerful. All trusts are estate planning. They still avoid probate. The irrevocable trusts avoid probate. They still put all the conditions of inheritance that we covered in our one of our first modules. And so this is not only powerful lawsuit protection, but it's also good estate planning value shifting. It can be called an estate freeze, depending on how it's done. And this, like Sam Walton used a family limited partnership, and he retained his minor ownership as general partner. And if you gift, his was like 5% or something, I can't remember what it was. 95%. If you gift whatever these assets are here at an embryonic value, and he runs this company or as a holding company, a bunch of under companies, and build it into a multi-billion-dollar empire, when he died, billions of dollars didn't transfer. The kids already owned it. They just couldn't control it until after Dad died. So it's great asset protection where they can keep control, and it's mainstream estate planning. It's very powerful, and you're saving dollars. So in illustrating this is fine when you have children and your estate's starting to grow. But if you don't have kids yet, you usually don't want to do this. I think I mentioned earlier, one of my first trusts was like this. It said, to my legally recognized children, if any, and if not, then to my nephews and nieces, mom and dads, if they're still alive. As soon as we had our daughter, Afia, everybody was aced out because she was a overrunning thing. It's not necessarily what I'd recommend for most people. If they don't have kids, they don't know if they're going to, even if they want them. They want direct access. They don't want to just get paid as a manager. They want to be able, hey, we worked hard, I want to take $1 million out and go to Europe before my knees get bad. And it has to be more regulated if you're not a beneficiary. Those are subtle things that we can talk to each member based on their circumstances and conditions. But that's more than Trust 101. It's kind of a little trust that we employ, whether it's on the estate planning or on the lawsuit protection side, it applies to the W-2 employees, and it also applies to real estate investors and regular entrepreneurs that are running businesses.
Well, that's great. That gives a great overview of it, and the fact that one of the things I get out of that is that it has to be tailored to every individual person. It's not you just go down to your local strip mall and go, give me a trust, and they give you trust.
No.
You can do that,
yeah.
but that's the wrong approach. You're going to get the wrong product because they're not going to tailor it to you. They're going to take their $100 or whatever they charge you and give you some package deal off the shelf that's not going to be tailored to the individual.
Right.
So that was awesome. It was great.
I think for everybody watching what Kevin talks about, that he knows a ton of information about this. And I was trying to give you an opportunity to kind of toot your own horn in the last video when I asked how many people do this, and not how many people come to you, but how many people, attorneys, lawyers, do the kinds of things that you're doing here. And I think it's only a handful.
Yeah, there's only about 8 attorneys nationwide that have a high profile, this is what they do, and they're waving their banner that this is their main focus, and have been in it for a long time. There are some very good people buried in big law firms, but they really don't get marketed as asset protection lawyers. They just handle their business clients that are already in that firm as an enhanced value. There are a lot of people that go to continuing ed seminars that I put on and those other 8 or so put on, and then they come away after they learn about charging order on a limited partnership and say, I'm an asset protection lawyer now because I can form LLCs for you. And yeah, it's a tool, but I can't tell you how many I've fixed. I think I mentioned in that module that they put them in as, the husband as the general and the wife as a limited, or husband and wife as general and their living trust is a limited, and you don't have an innocent third party. There's no charging order protection on that. So there's a lot of things to do wrong.
So I think it can't be understated with the value that we have as EVG members to having access to Kevin is probably one of the best in the nation at doing this. So as a member, you have that access. You can reach out to him by the contact information below as an EVG member, and we can get you guys into contact.
Yeah.
Great.
Appreciate
Thank
it.
you, gentlemen.
Thanks again, and
Thanks.
we'll see you guys next video.